Well, good morning, everybody. Welcome on this chilly morning to the Office of Open Records, where for this webinar, we're going to be talking about laws that protect information. So let's get a couple preliminaries out of the way. First offhand, I want to tell you that this session is being recorded, and the recordings are available a couple days after. First, you'll find them on our YouTube site, and then from there, we link to our website. The URL is on the screen right now, openrecords.pa.gov, so that let's say you have a colleague or friend who couldn't make it today, they can listen to the recording in a few days when our admin staff is able to load it onto the website. These webinars essentially are a PowerPoint presentation with me talking in the background. The PowerPoints also are on the website, so that if you have, again, a colleague who couldn't attend today, maybe you'd like it just for your own future reference, maybe you're doing some local training. All of our PowerPoint presentations that we use for all of our training are available on the website. They're public records. You can download them and use them as you see fit. This morning, like I said, we're going to be talking about laws that protect information. You can use the chat feature to submit questions as I'm going through the presentation, and I'll do my best to answer them live. But I have, two caveats here. First is, let's stay on topic. We're talking about laws that protect information. Second is do your best to keep your questions as brief and succinct as possible. Reason being, sometimes folks will type several paragraphs, pardon me, and it's just awkward for me to sit here, read through all of that while everyone else is sitting patiently, waiting for me to get through it. If it looks like you're asking about something that is unusually complex or unique to your particular situation, we'll do one of two things. We'll wait until the end of the presentation and I'll come back to it and do my best to answer it for the good of the order, or we'll take the conversation offline. Again, the contact information for our office is on the screen, and we'll ask that you reach out either through an email or feel free to call the office, and we'll try and get you headed in the right direction. Okay? This is an interesting topic in that the term isn't used that much anymore, but I always like to describe this particular webinar as crowdsourced. It started with a suggestion that came in from one of our viewers. Hey, why don't you guys do a webinar on this? And we took that, kind of ran with it. It took almost a year to put this together, but we asked the public, we asked our customers in municipalities, what would you like us to talk about? And then we also approached our appeals officer staff and took a look at the metrics. Okay, what other laws are you dealing with when it comes to making decisions related to right to know appeals? And that led to putting all of this together. And you'll see that we're going to talk about laws that we most commonly encounter here. There are other ones that come up from time to time, but we don't see them with the same amount of frequency. And this varies. We've got one that I've kind of sat on the fence thinking about, well, I need to take this out of the webinar. And just when I'm ready to do it, another appeal comes in where it deals with that particular law. So, bear with us with the lack of continuity. We kind of bounce around from different topics. But, hopefully you'll find this very useful. So let's dive into it and come over here in advance. There we go. Why is it important? Okay, question protocol, type it in the chat feature, try and keep your questions short. Okay, so why is this important? Well, first offhand, if you recall from sitting through the basics course, if you've had the opportunity to do that, remember the slide that says the right to know law is not a confidentiality law. Okay. The right to know law gives the agencies discretion in how they can, and if they choose to deny a right to know request based on the exemptions in the right to know law. Okay. But then you have a section in the right to know law, and I'm paraphrasing here, but basically it's section 306. Nothing in this act shall supersede or modify the public or non-public nature of a record as established by federal or state law, regulation, or judicial order or decree. Okay, what does that mean? Basically, it means that if there is another law other than the right to know law that makes a record confidential, that trumps the right to know law, meaning typically there is no discretion allowed in those other laws. Right to know law, it doesn't say that these records shall be withheld. Rather, it says that if these records fall within the definition of this exemption, the agency may withhold. Well, when you look at these other laws, they typically use the word shall. I mean, there is no discretion. If someone requests a record that falls within this definition, you will not give it out. You shall not give it out. Okay, so right to know law, you have a degree of discretion. These other laws that we're going to talk about here this morning, for the most part, there is no discretion. If there's a confidentiality clause in those laws, you don't give out the record. So that brings us to the second reason as to why it's important, and that falls under the burden of proof aspect of the right to know law. And if you look at section 708A1 of the right to know law, it is the agency or the local municipality, or it could be an authority, it could be a school district, it could be a charter school, that bears the burden of proving why a record should not be released into the public domain. What if that record is not defined within the right to know law? Well, you could very well rely on the confidentiality provisions of these other laws as your legal basis for withholding the record from public release. And these are the laws that we're going to be talking about this morning. In many instances, there is a provision within the right to know law, because remember, there are 30 exemptions. They cover a broad spectrum of records that, in looking at, you would think, well, yeah, it would not be appropriate to release these. But there are those instances where you will find records are not covered by the right to know law, but there is another law that is prevailing. Not to give legal advice, but if you're writing a denial letter and it's covered by the right to know law and the other law, I would reference both. That way you're solidifying your case and strengthening that burden of proof that you're using as your legal reasoning for withholding the records. Okay, so that's why having a basic knowledge about these other laws is important. All right, so let's advance and talk about several of these laws specifically. And the first one is probably the most common one that we deal with here at the Office of Open Records, and it's called CREA, the Criminal History Records Information Act of 1980 in Pennsylvania. And this applies to any person or agency that collects criminal history information. It could be a police department, prisons, district attorneys, sheriffs, courts, or whomever. And CREA protects criminal history, investigative, and intelligence information. All right, now you're thinking, okay, I'm familiar with the right to know law. Isn't this section 708B16? In many cases, it is. There's duplication between that exemption within the right to know law and CREA. But I will tell you that CREA goes into much greater detail and casts a somewhat broader net as to what records should be withheld. For instance, you see here in red intelligence information. if you look at Section 708 B16 of the Right to Know law, there is no reference to criminal intelligence information. So let's say, I'll use an example here real quick. Someone submits a right to know request for the file that a police department keeps on suspected gang activity, okay, intelligence information. The police department naturally would not want to release any of this information, but they look to the right to know law and they don't find anything. So then they go to CREA, which covers their operations, and sure enough, CREA goes into detail on what defines criminal intelligence information. So when they're writing out their denial letter, they make a nexus between the file that's been requested and the language within CREA that says you shall not give out this information. As a matter of fact, there are actual criminal sanctions that if a police department violates CREA, then charges can be brought against the culpable party, and they would be subject to sanctions of some sort. And I also want to emphasize that within CREA, the identified records can only be shared with other applicable law enforcement agencies. And I emphasize this because different laws have different definitions of what a law enforcement agency is. And I think it's important to realize that distinction. CREA has a more, how would I say it? A more common understanding, if that makes sense, as to what a law enforcement agency is. And, we've got them at the top. There are other laws, for instance, Act 22 in Pennsylvania. Act 22 is the law that governs access to dash cam, body cam, and security camera footage. Believe it or not, Act 22 defines a law enforcement agency as any entity that employs a law enforcement officer. So under Act 22, believe it or not, a school district could be considered a law enforcement agency. Okay, so you've got that definition as it applies to that law. That definition, however, does not apply to CREA, which has a much narrower definition of what a law enforcement agency is. So you need to be aware, and my mantra when trying to understand a law, always go to the definition section, because that sheds light on a lot of things that may not be particularly clear when you're reading through the law itself. And this is one of those instances. Be aware of what defines a law enforcement agency, because in CREA, you've got a fairly standard definition. In Act 22, you've got a definition that, to use a legal phrase that some folks have used, is somewhat absurd. Okay, so you need to understand that distinction between these definitions. But I'm digressing here. Let's get back on topic. There is a very good resource for understanding CREA and how it works, what it says, with the Pennsylvania Office of Attorney General. And they also have staff who are up on CREA, so that if you do have questions, you can reach out to them. They're very helpful, but I would recommend downloading their guidebook that they have on their website. I haven't checked this link in quite a few years, but it used to be good, and it's an excellent guidebook. So take a look at that. Okay, moving on. Act 30 of 2016 applies to, public safety answering points. These are 911 centers, but it's the term that's used in the law because not all calls for help from emergency services necessarily go to 911. So they define them as public safety answering points, or, for our purposes, for the most part, it's your county 911 centers. And Act 30 protects individual identifying information. Okay. This would be name, telephone numbers, and home addresses of anyone who calls the 911 center, 911 center, okay, and then witnesses to yeah, they pay me to talk, incidences, um, and the names or identifying information about victims. And it's so that, there is no fear of names being released into the public that could result in bad things happening to those people. Um, and this, we see this a lot. And I am relating this anecdotally just from the number of emails and phone calls that we get here at the office, where people are seeking the recordings of 911 calls. And it could be they made the call themselves, or it could be it was for an incident that occurred at their home and they want a recording of whoever called it in. Okay. And who knows for what reasons? It could be perfectly legitimate, or maybe they're concerned or looking at some form of retaliation. Act 30 prevents getting access to that information. And if you look at the right to know law, Section 708B18, it is probably one of the tightest written exemptions in the right to know law. And it basically says you're not going to get a copy of that recording. Now, it doesn't protect the location in a general sense, okay? For instance, and this is usually what happens, the 911 center, the emergency management administrator, for media purposes, will release the block number or the cross street, or in some instances, the mile marker, depending on the incident. Right now, I'm sitting in a building. The address is 333 Market Street, Harrisburg. If there were, an incident here, let's say the fire alarm in the fire department shows up, they would release to the media that there was a fire incident at 4th and Market Streets, at a building at 4th and Market Street. Or they may say the 300 block of Market Street. Okay, they can do that, but they cannot say the address was 333 Market Street. Now, you're saying, well, I've seen it in the media where they put the exact address. And that's usually the reporter figuring it out, seeing the fire trucks in front of this building so they know the address. But all of this other information, individual identifying information of callers, witnesses, and victims, is protected by Act 30 of 2016. The emergency call centers cannot give out this information in response to right to know requests. Okay, switching gears a little bit, let's talk about attorney-client privilege and work product. This comes up when folks, for the most part, want to see communication between solicitors and their client agencies. Usually it's like a solicitor and a borough or township. School districts are a big one. And attorney-client privilege protects any sensitive communication between lawyers and their clients that involves legal advice and strategy. Okay. Overarching definition of attorney-client privilege, it applies to anyone seeking legal advice from their attorney. For our purposes and right to know, dealing with government agencies, you're talking about solicitors and typically mayors, city councilmen, township supervisors, school board members, school board senior management, and the like. Okay. In Pennsylvania, attorney-client privilege is specifically referenced under the rules of evidence, which is statute. So there's a statutory grounding in attorney-client privilege. And I do want to emphasize that you can lose privilege if it is shared outside of the attorney-client relationship. Okay, and this comes up periodically where a solicitor will meet with a board, and you have someone on the board that goes rogue, and they'll immediately go out and say, well, the attorney said this. Okay, when they do that, when they share this information with a third party, privilege no longer applies. Privilege is lost. Okay, there is no remedy for this sort of occurrence within the right to know law. And I think it becomes a matter of what do the appropriate codes that govern the activities of that board allow for any sort of sanction against breaking privilege, but it's not covered in the right to know law. The Office of Open Records has no jurisdiction over anything like that. When it occurs, we only deal with whether privilege applies or not. Okay. A lot of times folks are looking for copies of the legal invoices. Essentially, all they want to know is how much our municipality is paying our solicitor. And again, that depends on whatever sort of contract exists between the solicitor and the municipality. Um, but it also depends on how detailed the invoices are. Now, if your attorney, if your solicitor, let's say monthly, they're simply submitting an invoice that says, for the last 30 days, I worked 17 billable hours. And, at my rate, this is what I'm due to be paid. Okay. There is no mention of anything that would reveal legal strategy. So in most cases, and, I'm sorry I have to backpedal a little bit. But in most cases, or qualify my statements, um, that would be considered a public record because it's a financial record and you're not revealing any sort of legal strategy. But let's say perhaps your solicitor goes into greater detail and says, for the last month, I spent 3 billable hours researching these legal cases that relate to our anticipated defense in this pending court case. I deposed or I conducted initial interviews of these particular potential witnesses because I'm looking at putting together this sort of strategy. And you get what I'm saying. The invoice goes into such legal detail that you can discern legal strategy. Then you could make the argument that, yes, this is covered by attorney-client privilege and it should be withheld. Now you're sitting there with your eyes crossed thinking, well, how do I figure this out? Our advice is that if there's any question as to whether attorney-client privilege applies, go to your solicitor and ask them for their opinion on it. If they say withhold it and the requester disagrees, they have the right to appeal and we'll sort it out on appeal. But I would suggest deferring to your solicitor, get their opinion on whether attorney-client privilege applies, and proceed from there. Question has popped up. Is confidentiality lost only when that specific information is shared and not the overall topic? That's one of those questions where I got to say it depends. Okay. You're going to have to look at the specific circumstances and make a determination as to whether attorney-client privilege has been broken or not. Yeah, there just isn't enough information for me to give you a definitive answer. So again, I'm going to have to qualify it. Okay. And there is a reference to attorney-client privilege, again, in the Right to Know law, Section 305A2, for a reference that recognizes the confidentiality aspects of attorney-client privilege as it relates to the right to know. Okay, shifting gears once again, and this one comes up again. I shouldn't say I'm surprised, but I recognize just how commonly it comes up, and it is the Uniform Construction Code, or what commonly in parlance is known as the UCC. It is Pennsylvania's statewide building codes, and it applies to any agency that would be in possession of building permit applications, plans, and associated records. So what does it protect? Well, yes, it protects those applications. It protects building plans. specifications, inspection reports, and similar documents. Okay, so you've got a somewhat subjective term in there for buildings constructed after 2004. Okay, why 2004? Well, that's when the UCC was adopted by Pennsylvania as the statewide building code. I'm old enough to remember pre 2004 when we had a mishmash of building codes that were municipality based. And it was a real challenge for contractors and developers that would work in multiple municipalities because you had to know what law was in force. And we had, let's see, there was one called the BOCA Code. There was the Uniform Life Code. And then you had local codes that each municipality would come up with their own. And it was just all over the map, a real patchwork. So the state adopted the UCC. So what if you encounter a building that went up pre-2004? Well, you've got to find out what code was in effect at that time and what the confidentiality provisions are of that particular code. So yeah, you would have some research built into it. But we're here to talk about UCC since that applies to most buildings that people are asking about. Now, the permits themselves, the document that approves the construction or the modifications or whatever, those are public records, okay? But the documents that are part of the application process that led up to the issuance of that approved, building permit are considered confidential under the UCC. Now, there is a decision, and you need to be aware that you've got the right to know law, and then you have case law. Okay, case law is the body of decisions that have come down from the courts as well as the Office of Open Records that have been issued that contain language that clarifies how the right to know law should be applied, as well as some of these other laws in relation to the right to know law and right to know requests, that in many instances they add clarity. In many instances, they take account of advances in technology and add to our understanding of the law, okay? So we've got a body of case law related to the right to know law. And this is an example of one that you need to be aware of. Many people have a misunderstanding that the UCC only applies to commercial structures. Under our decision, Ness versus York Township, which we issued back in 2012, the Office of Open Records ruled that the privacy language within the UCC also applies to residential structures. Most of the UCC, you'll find language, commercial structures, commercial structures, commercial structures. You go to the confidentiality provisions of UCC, and it no longer uses the term commercial. It simply refers to structures in a generic sense. Our office took that change in language. So it's not so much what the law says, it's what the law doesn't say. And we ruled that the privacy provisions within UCC extend to residential structures. So if you get a right to know request for, let's say, the building plans for a residential structure, you can deny them based on the language within UCC. And furthermore, you can refer to this decision, Ness versus York Township, as further legal basis for your denial. And this has never been challenged. It's never been, elevated to a higher court. So OOR decisions carry the weight of law. Thus, this is the law. And Many codes enforcement officers are not aware of this court decision, but think about it. Why would you give out any residential building plans to just anybody who's asking? Now, I do want to say that within UCC, there is a provision that allows the release of records to anyone who has a legitimate need to know. For instance, if you have a new building owner and they want to see the history of changes that were made to the structure over the years, or if you have a building contractor who's been hired to come in and make, new changes to the building, and they need to see what was done in the past, what's behind this wall. So they need a copy of these detailed plans. You can give them out to that developer, to that contractor. Okay, UCC allows that so that if there is a need to know, you can give them out to those parties. Now, if there are any building code violations, that's a separate issue. Okay, that they are court records as they advance through the appeal system, and they are accessible through the court system. So they may not be accessible through Right to Know, but as court records and using their system for gaining access to records, you may be able to get any records that led to legal action that had their genesis in a building code violation. Okay, and then we get questions about zoning boards, and the like. Access to zoning records are covered under the municipality's planning code, which is a separate and distinct law in Pennsylvania that you want to become familiar with if you have questions about, how did it come about that this particular property is subject to this particular zoning. Okay, municipality's planning code will get you headed in the right direction there. Okay, sip of coffee here quick. Okay, let's take a look at the alphabet soup of laws that relate to health records. Yes, within the Right to Know law, you're going to find exemptions that clearly cover employee medical records. Okay, they're off the table, not accessible as it should be. But then you also run across a number of federal laws that also relate to health records. And I want to emphasize that there is no discretion. Okay, the law says clearly that you do not give out this information, you do not give out these records, and if you do, there will be a sanction. It could be civil, it could be criminal, it's just going to depend on the circumstances and the provisions within the law that relate to whatever sanctions may be appropriate. So the first one we want to talk about is the oldest one, and it's known as HIPAA, the Health Insurance Portability and Accountability Act of 1996. Now, HIPAA primarily applies to healthcare providers, not to employers, but yet there may be instances where a municipality qualifies as a healthcare provider based upon what used to be known as the old county home system. And there may be direct control of such a facility still in existence, or it may be through a contractual relationship where the county pays a private provider to provide medical services. And if through that contractual relationship, you could argue that the county or maybe some other municipal entity is in possession of personal health information, HIPAA would apply. And HIPAA basically says that individual health information is off the table. It is confidential, and you do not give it out under any circumstances. Also under HIPAA, we do want to note, however, that an employee can approve the release of their individual identifiable health information to an employer. But then the employer must keep it secure, okay? And we'll talk about in the context of another law how this might occur, where an employee voluntarily releases their health information to the employer. Okay, so let's move on to the next health-related law, and this does relate to municipalities as employers, and it's FMLA is the acronym that's used, and it's the Family Medical Leave Act. Okay, now this applies to all employers and specifically any human resource leave administrators and their supervisors. It protects any leave or accommodation related records that could disclose the presence of a serious health condition. Now, first offhand, back in a prior career, I was the human resources director for a large state agency. And prior to FMLA, all the health information was kept in the same personnel jacket. FMLA came out, and any health-related information had to be kept separate in a separate file. It was kept under lock and key, and you had a much narrower scope of a much narrower universe of people who had access to those records. For instance, as the HR director, I could not see that information. Only my benefits staff could. So, it really, things were clamped down on who had access to benefits information. So, leave information, okay? And I think it's important that we talk about this for a second, because occasionally you will get folks who submit a right to know request. I would like to see the leave records for this particular public employee. And who knows, maybe it could be election season. Maybe it's a nosy neighbor who is curious about someone being home during work hours, et cetera, et cetera. Here's the issue. Under FMLA, if a public employee, well, actually, if any employee is off for 3 consecutive sick days, the HR office should be sending them a survey form where they essentially ask the question, was this absence due to a serious health condition? And depending on the answer, then that's how they charge against what's called the FMLA leave entitlement. Okay. Because under FMLA, you're entitled to X number of days of FMLA leave. Now, if someone submits a right to know request for that person's leave usage, and they see 3 consecutive days that may have been charged against FMLA, think about this, make the nexus. You can then potentially determine that this person suffers from a serious health condition, and that is confidential. Okay, you do not give that information out, that a person has a serious health condition. So you can see how you would mistakenly release that knowledge by giving out the leave information. So you need to be very careful about any sort of leave entitlements that you release. Or I should say, a leave entitlement is probably public. Leave usage that's charged against that entitlement is not, because you could potentially be divulging the presence of a serious health condition. So as public employers, we need to be very careful about what sort, if any, leave information we give out, because it could potentially violate FMLA and subject that person that responded to the right to know request to civil sanctions. Okay. All right, moving on. The next one is the Americans with Disability Act, ADA. Again, this applies to most employers, and it protects all medical records and requires that they are stored separately from other personnel records, just as you'll find in FMLA. Okay, now, information can be provided by an employee voluntarily to their employer. Typically, also, let's say it's not necessarily in the context of a health-related survey or inquiry, but a non-medical inquiry. So here's the example that I like to use. Let's say you have an employee who suffers from epileptic seizures. No, no, let me use a different example. Let's say that they have a hip injury, okay, that makes it difficult for them to walk downstairs. And there is the agency is located in a multi-story building, okay, city hall, township building, whatever. There's a fire marshal, okay? They're an employee who's responsible for overseeing what staff does in the event of an emergency. And, you know, if they have to evacuate, the fire marshal is in charge until the emergency services arrive. So they conduct a survey of employees, you know, in the event of needing to evacuate the building, do you require anything special from the fire marshals or the assistant fire marshals? So this employee with the hip injury says, yes, I cannot walk downstairs and the elevators are not available during a fire drill. So I'm going to need help getting out of the building. So the fire marshal, through a non-medical inquiry, becomes aware of the fact that this employee has a hip injury that requires special consideration. So what they do is they have the assistant fire marshals take them to the stairwell and shelter in place there until the fire department arrives. Then the fire marshal notifies the fire department, we have an employee and some of our staff waiting in place in the fire tower on the third floor. So you need to go evacuate them. Okay. The fire marshal is only releasing this information on a need-to-know basis. It is not telegraphed to all of the staff, but only those staff that need to know this in order to help the employee with the hip problem. Another example, and I'll go back to, you know, what I was saying about the employee who suffers from epileptic seizures. They would notify their supervisor, maybe the HR department, hey, I'm an epileptic. If I happen to have a seizure, this is probably what's going on. So yeah, the employee has a seizure. The ambulance service is called. They show up. The supervisor then notifies the first responders. The employee has told us they suffer from epileptic seizures. That may be helpful to know here. Okay. They haven't telegraphed it to all the staff, rather only the immediate supervisor and the HR department is aware of the presence of this condition. Okay, that is entirely legal under ADA so that you can let staff know this. But in the context of right to know, you would not release, you know, for instance, if you got a right to know request of all employees with, you know, some sort of medical condition. And who knows why they would be asking this, you know, for any sort of records of that type. But basically, ADA says, no, you don't give out this information under penalty of law. Okay, shifting gears, school districts. This is a big one that they deal with. FERPA, the Family Educational Rights and Privacy Act. FERPA applies to public and private schools, primary, secondary, and post-secondary, and it protects individual educational records, which could be report cards, transcripts, records of discipline, and the like. Okay. So if I submitted a right to know request to a school district and I wanted to know the grades that everyone in my son's class got on a test because I think my son was treated unfairly, the school district would deny that right to know request based on the provisions of FERPA because I'm not entitled to individual educational records. Okay. Now, You're thinking, well, what about when the school releases the honor roll? And I don't know if they still do this, but it used to be, every quarter, the local newspapers would list those students that made honor roll. Okay. Well, those are considered or defined as directory information. Same way with sports. Okay. High school sports. So and so, they got accepted to this particular college based on, and got a scholarship, full ride or whatever, where they signed that, what do they call it? Their letter of intent, I think, and they have a signing day, and that makes the paper or the website or whatever. Again, it's considered directory information, even though technically it's an educational record. Because it's directory information, it can be legally released. Okay. Now, aggregated reports of grades, those are public. And school districts nowadays, they've got to submit reports to the Pennsylvania Department of Education, the feds, and the like. There's all kinds of reporting that they have to do on an aggregate level because it may affect their funding. It may affect overall scores that the district gets on performance, et cetera, et cetera. Those aggregated reports are public unless you can slice and dice them down to the individual level. And we do have a couple decisions where the school district raised the issue and they showed us, and it basically had to do with the fact that the sample was so small that someone familiar with the district could determine, and it came down to ethnic data, that um, knowing the ethnic data, knowing who was in the district and in this class, you could determine that this particular student got this grade, and you could take it down to the individual level. If you can do that, looking at the otherwise aggregate data, then you can withhold those sort of reports. But if you're talking about a large sample where you cannot slice and dice it down to the individual level, typically that would be considered a public record and it would be released. Now, interestingly, we get calls and emails from parents who say, I wanted information on my child. So I submitted a right to know request to the school district and they denied it and they referred to FERPA. Okay. Technically, the district can do that. But what they're failing to do, and shame on those districts, is that within FERPA, there is a provision that allows parents to see the records of their own minors. Okay. And if they follow those provisions, then FERPA allows that. And because, a right to know request would never be filed, then the right to know law obviously wouldn't apply either. But, it surprises me how many times we run into instances where the school district says no, but then they don't go on to explain that if you look at FERPA, there is this mechanism that allows you to see this. Now, I should say most school districts will comply and they're more than accommodating to the parents. It just surprises me when we see instances where they're not. And foster parents, I'm not sure the legal status. I think if the student, if there's that official guardian relationship, then I think it applies. Okay. For foster parents, I just don't know enough about the legal status of a foster parent to determine whether or not they could use that mechanism within FERPA or not. I just don't know. I'm sorry. Okay, but it's something, maybe you want to take a look at if that does apply to you. Okay, so what if you've got a student who's going to college and they get themselves in legal trouble with the campus police? Those records are not protected. Okay, they're considered criminal records and not individual educational records. So they would be subject to the right to know law, but on another level. FERPA would not apply. And then I want to emphasize, or at least bring to your attention, that in recent years, case law has been developing on school videos, okay, video cameras on school buses, within school buildings and the like. And you've got this distinction between Act 22 and the right to know law, and whether or not these video records are considered public records. And unfortunately, I'm going to have to say it depends. Okay, as it is now, it's case specific. We've got court rulings where the courts have said these are public records and they don't involve any individual educational component. And then we've got other court decisions that say they are confidential. And then we've got some that say you can release them, but you need to uh, uh, gray out the faces of the students. Okay. So, this is an evolving area of case law. And I would suggest taking a look at our website, doing a search on final determinations, and also take a look at our case law index. And you'll see kind of where things are headed as it relates to students, FERPA, and the release of video information. And then finally, student health records. If there is a dispute over the release of any potential student health records, FERPA is the controlling federal legislation that applies, not the health-related legislation or laws that we talked about previously. You would use FERPA as the controlling law that would determine whether or not health records should be released or not. And I should say, for the most part, health records are considered individual educational records. And because of that, Pennsylvania, within the public school code, has made it quite clear that all health records in possession of a school district are considered confidential. The school code is pretty much a state extension of FERPA, and it applies to any public school employees and officials. That would include school nurses, nurses' aides, and the like. So if you have, for instance, a nurse's aide who's responsible for making sure a student gets their medication at lunchtime every day, they keep records to that effect. Those records under the Pennsylvania School Code are clearly off the table. Okay, they would not be released in response to any sort of right to know request that would be seeking those types of records. All right, shifting gears once again. Oh, you see what I did here? We're talking about the Pennsylvania Motor Vehicle Code. Okay, driver's license information, typically of public employees, are considered confidential under the Pennsylvania Motor Vehicle Code because they represent an individual driver's record. Okay, we get into this where municipalities may have driving records on file because of commercial driver's license requirements. Okay, the township or borough or city has a piece of equipment that's of a specific type or gross vehicle weight that it requires that anyone operating it have a CDL. Well, that CDL represents an individual driver's record. And under the Motor Vehicle Code, Section 6114, it's considered confidential. You do not release this, okay? And I haven't seen this come up for a couple years, but I remember actually getting a phone call from a woman. She was in a small town, and she was involved, with local government, although she was not a public employee or a public official. But she saw an employee driving a particular piece of equipment, and she thought, I bet he doesn't have, I shouldn't use that voice, but I bet he doesn't have, a license to operate that big truck. Well, she submitted a right to know request. They denied it. And I told her, CDLs under the Motor Vehicle Code are considered confidential. And she just had to grin and bear it. Okay, now, what if you have a public employee who has a DUI or they've got a problem running red lights, okay? That becomes, again, a criminal matter, a court matter, and court records are accessible in Pennsylvania, but not through the right to know law. They're accessible under, I think it's called the 519 process through the court system. That's how you would get access to any public employee criminal related legal action. Okay, the copyright law, federal copyright law of 1976. This comes up periodically when there is a belief that an architect or an engineer has claimed copyright protection for drawings or plans that they have submitted to a municipality. Okay, now the copyright applies to anyone claiming or using intellectual property in the form of authorship. Okay, they're saying what I have prepared here represents individual thought, okay, or intellectual thought, and I don't want anyone misusing this, so I'm going to claim copyright. Now, copyright protects those records where the author is claiming this original thought. Typically, we come across it when it comes to engineering or architect plans and drawings. All right, new subdivision going in, or maybe it does deal with building plans. Maybe it has to do with stormwater runoff construction that's taking place, and someone wants to see, what sort of drains and culverts are going to be installed. Now, usually, there are what are called standards of practice within, the architectural world or the world of engineers. So for an engineer to claim original thought would then mean that they are deviating from standards of practice, which could be problematic. Okay, I'm not aware of any engineer really intentionally claiming original thought when it comes to design, at least not that I'm aware of. Okay, the misunderstanding usually occurs when someone who is not familiar with copyright sees a stamp on a drawing and they assume that, okay, this is copyrighted. In most instances, there will be a stamp affixed to a drawing by an engineer or an architect, and it's their licensure stamp. They're basically saying, I am a licensed engineer, or I am a licensed architect, and this stamp validates that I am thus qualified to prepare the drawing that you're seeing in front of you, or that I am submitting for this project. Usually with copyright, there would be a second stamp where the architect or engineer is saying, oh, and by the way, this drawing includes original thought, and thus I do not want this shared. Okay, so what's the agency to do when someone requests a copy of those records through a right to know request? Well, it turns out that there is a court case that is controlling. Case law is available, and it's Ali versus the Philadelphia Housing Finance Authority, where the Commonwealth Court, in applying the right to know law, basically says that if someone submits a right to know request to see a copyrighted record, they can inspect it, meaning they can see it, but they may not have a copy of it. Okay, inspection, but not a copy. And that satisfies the provisions of the copyright law as well as the right to know law. Now, what if, when you're not looking, they take out a cell phone camera and snap a picture of the copyrighted record? Well, have no fear, because under the federal copyright law, any dispute is between the person claiming copyright and the person allegedly misusing the copyright. And simply snapping a picture is not misuse. Okay, they would have to do something with that picture. And the degree of liability for the agency would be very small at that point because, they're just caught in the middle. The dispute is between the person claiming copyright and the person allegedly misusing the copyright. Okay, just in case that should happen. But you need, the big takeaway from this is understanding what copyright is and the fact that just because it has a stamp on it doesn't necessarily mean that the person is claiming copyright. It may simply say, this is my licensure stamp that they're affixing, which should be on most drawings and associated documents. All right, shifting gears once again, the Child Protective Services Law. You're thinking, okay, why would my little township be subject to this? Well, what if you have a summer kids program? Maybe you've got a network of township parks. Okay, those parks run summer programs for kids. Well, any volunteers or employees that oversee those programs who have contact with these kids needs to be certified through the Childline, the state Childline program, which falls under the Child Protective Services Law. Okay. And let's say that a kid shows up who has some unusual bruising. So the volunteer is now legally obligated to report any suspicious injuries where they think child abuse may be involved. Okay, they're legally bound to do that. So any copies of reports, any investigatory records, medical evaluation, and the like concerning an investigation of child abuse is protected under the Child Protective Services Law. Anyone who's initiating such an investigation is treated as a confidential informant, as any other criminal potential law would cover them. Okay, and that threshold is high. Okay, so all that information would be protected under Child Protective Services Law. Now, where we run into problems, and I shouldn't say problems, I'll just say awkward situations, is when it comes to custody issues with a family. Okay, you've got spouses who are either divorced or in the process of divorce, and that gets muddied with child abuse claims that may have been initiated by one of your volunteers or employees. Okay, and we get it here when you've got a very frustrated parent who's calling, who's saying, look, my spouse is claiming child abuse and I can't get access to anything. And, I want to file a right to know request to get this information. Why can't I get it? The Child Protective Services Law is the reason why. It becomes very difficult because the agency is put in the middle. Okay. Well, at the end of the day, the Child Protective Services Law prevails. You've got to follow what it says and protect this information. That person who's calling, as frustrated as they may be and as empathetic as you may be to their situation, chances are they have an attorney. If not, they should probably get one. And then that attorney can use the appropriate legal mechanisms to get access to any possible child abuse records. Okay. But it's through the power of subpoenas and court orders that they gain access to this information, not through the right to know law. Okay. Don't use the discretion that's afforded in the right to know law to mistakenly release this information that falls under the Child Protective Services Law. Okay. The language in this law prevails. And, like I said, you're very anxious because you're put in the middle. You feel for the person, but you've got to follow the law. Okay. Don't use your discretion to release information that you shouldn't release in this particular instance. And then any of the applicant information that people use to get their child abuse clearances, that's protected and should not be released. Okay? Something that's somewhat related, but on the other end of the perspective, yeah. I'm, the other end of the spectrum is the word I drew a blank on, is the Older Adults Protective Services Act. Again, this goes into municipalities and agencies that may deal with older citizens, older residents, where again, either directly or through a contractual relationship. But here it's deals with these senior centers and those who are providing direct care. Okay, so it protects all reports of abuse or neglect, investigatory materials, assessments, and service plans. So you're talking about primarily employees and administrators of elder care facilities. Okay, and this is that one that I'm thinking, okay, we haven't seen anything for quite a while. Maybe we ought to take this off the webinar. But then it comes up, and it's usually like county authorities on aging and the like. And the law is intended to ensure that the protection and safety of adults over 60 who cannot protect themselves. Okay, it's not just anyone over 60, but who cannot protect themselves, and they are at risk of abuse or neglect. If an employee or administrator suspects any sort of neglect, then they have an investigatory mechanism, and obligation to follow those mechanisms to investigate. Okay, so if someone receives a right to know request for a copy of suspected elder abuse and the investigation that takes place, this law is prevailing. And sure enough, we got a call from the state agency on aging or Department of Aging, and they were dealing with a right to know request. And this was just a couple months ago. So I was thinking, okay, well, we're going to keep this in the webinar because it applies to those county agencies as well. So that, it must be an issue that's coming up. But this law prevails, okay? All right, and here's another one that has not come up in quite a while. This is like a COVID-based issue that saw a lot of activity back during lockdowns and the like, but we have not seen anything for at least a year on developments like this. But periodically, we hear rumblings out of the legislature about modifying this law. And essentially, what this law says is it was used as a defense by the Pennsylvania Department of Health and those counties that have their own boards of health to withhold any record related to COVID investigation and record keeping related to infection rates and the like. And this law protects any reports of diseases, reports of action, or any records from release outside these boards of health. Okay. Now, our position always was that this law does allow the release of aggregated data. This is where the Department of Health and the county boards pushed back. For the most part, the courts supported our position on this, and it does allow the release of aggregated data. Okay, now the legislature, periodically, we will hear someone introducing a bill, and it's in committee where it reinforces the current case law on this, where it says aggregated data is public. All right, now I'm not aware of any court action within the last year to modify, what's taken place here. But, if we see a resurgence, and I always think it's a good idea, to consider this as the winter season approaches, this law will probably come to the forefront once again and be, be on the table. So you should be aware of its presence out there if by chance you are dealing with COVID specific or pandemic specific related records. Okay, and then just some miscellaneous things before we close up here. W-2s, they are considered confidential per the Internal Revenue Code. Okay, you do not give out W-2 information. Periodically, someone will want to know the compensation for employees, contractors, and the like. So they'll ask for W-2s or 1099s. You do not give those out under potential violation of the Internal Revenue Code. Same way, Pennsylvania records, taxpayer bill of rights makes it a misdemeanor to release any confidential tax information. Most tax information is confidential, so you don't give it out. We've also got a law called LT, the Local Tax Enabling Act, which protects that information that may be obtained by a tax authority or a municipality from some sort of investigation taking place or just from receiving tax returns. Okay, you don't give out tax information in almost all cases. There are those cases, though, where a commercial enterprise is in arrears on their local taxes. Okay. In those instances, case law supports that information being public. Okay. All right. Some questions have popped up here that I should jump into. The definition of aggregate sample size, no. That's a very good question, but again, I think it's going to be case specific. There is no standard defining what an appropriate sample size is as it relates to aggregate data. It's going to be case specific. Can I get a copy of the slides? Yes, as I indicated at the beginning of the webinar, you can find the slides on our website under the training tab. I don't know why you lost audio and you can't hear me speaking, but you can try logging off and logging in again, but we're almost at the end here. I'm sorry, I can't help other than that. And since you lost audio, you can't hear me saying this. Okay, so let's get back to the slide. Home addresses, dates of birth. Okay, again, this comes back to case law. Back when the right to know law was first enacted, home addresses were considered public information. Then there were cases related to school districts where ultimately the Supreme Court of Pennsylvania recognized what's known as the constitutional right to privacy, which in essence, they said home addresses for public school teachers are now off the table. Over the years, both the courts and the Office of Open Records have expanded this so that in most instances, any home address, whether it involve a public employee or a resident, usually is considered confidential unless the public right to know outweighs it. And usually that comes down to residency issues related to public officials. But for the most part, home addresses, confidential. Then you get into dates of birth as they relate to like identity theft and all of that. Okay. Again, case law applies. The month and the year of a date of birth is considered public in most instances. The actual day, however, is confidential. You would not give that out. Okay. Another question has popped up here. What about a request for real estate school taxes, including the names? The DCD report is referenced. Okay, good question, Donna. And I don't, yeah, I'm thinking where current case law is. That DCED report, if the municipality has it, is considered a public record. Okay, and it's a really odd situation where under the right to know law and case law where this constitutional right to privacy is referenced, okay, then it's confidential. But if the right to know request, or if they use another avenue, for instance, if I want to know somebody's home address, I can go to the county election board, okay? And if someone has registered to vote, I can get their home address because you've got that residency aspect. Or, quite honestly, if you guys want to know my home address, just Google my name and my home address will be within the first half a dozen hits. Okay. And that's what, interestingly, when this was all coming up through the appeal process, the Pennsylvania Commonwealth Court said that home addresses, are public because you can get access to a home address, County Election Bureau, just Google it or whatever. Okay. But then it got appealed to the Supreme Court, and the Supreme Court used this constitutional right to privacy. Okay, so you could argue both sides of this. But to answer your question, if the home address is available through the tax bureau and the tax information might be one of those rare documents that is considered public, then yeah, you would release it, but not through the right to know process because of the constitutional right to privacy. So, Donna, you raise a very good point. There are very easy ways to get someone's home address, just not through the right to know process. Okay. And that DCED report, that's a story within itself because that involves tax collectors. And under the Pennsylvania tax code, they are not subject, or tax records are not subject to the right to know law. Okay. But if the tax collector gives that DCED report to the municipality, then you can get it through the municipality. And so it's, it's a darned if you do, darned if you don't sort of scenario. What I discovered several years ago is that most tax collectors don't even know that report exists. So they don't give it out. And you're raising the issue because there is a private commercial entity that submits right to know reports or right to know requests for that particular report. And they can't get it from the tax collector because of the tax code, and they can only get it from the municipality if the tax collector gives it to the municipality, and most tax collectors don't bother. So it's kind of interesting. Okay, but enough said on that. I'm kind of getting into the weeds here, but good questions. Okay, we are at the end of the presentation. If you have any further questions, now's the time to get them in. In the meantime, I'll just talk about our website real quick. Excellent resource for information on the right to know law. Much of what I've talked about or mentioned here today, you can find on the website. The Final Determinations database, if you want to do some research on how our office has ruled, you can go in there and search. The Case Law Index, that's also on the website. Then we have guides for citizens, guides for agencies, and the like. If you're here today and you happen to be a newly appointed agency open records officer, take a look at our guidebook. 78 pages you can download for free. If you've never read the Right to Know law, you can download that from the website. It's not a hard law to read, okay? But if you happen to be a real geek about government transparency, you can subscribe to our Twitter feed, where every morning at 7 a.m. we will wake you up with all the news that's fit to know for the day on government transparency. Decisions that we've rendered, court cases that may have come out the day before, training opportunities, and the like. Finally, if you want to reach out to our office because you have some issue or question, use the phone number that's on the screen, refer to our website, and we will help you out as best we can. We have a crackerjack administrative staff. They will be the first one to get your questions, and usually they can get you steered in the right direction. If you happen to stump them, they'll escalate it up to one of our senior staff, and they usually can get back to you within 24 hours. We cannot write requests for you. We cannot respond to requests for you. We cannot talk about active appeals, but we can still get you headed in the right direction in most cases. Okay, we will help you out as best we can without violating, what we basically aren't allowed to do. Okay, which is advocate on your behalf. All right, so I don't see any more questions coming in, but I want to thank you for those questions that you did submit. And hey, stay warm out there today. Things are warming up later this week for most of us, but it's a chilly one out there. So stay safe and stay warm. And in 2 weeks, we will have a webinar on the Pennsylvania Sunshine Act, which will include discussion on the new court case, Coleman versus Parkland, which affects the agenda provisions. Okay, and it's a significant change based on the Commonwealth Court decision. So we'll talk about that in 2 weeks. Hope to see you there, but have a good rest of the day, and we're going to log off now. Take care, folks.